Okay, welcome to the Data Practices Potpourri webinar with the Data Practices Office. Thank you for joining us today. And before we get started, I do want to take a quick second to let everyone know that it is the Data Practices Act's birthday today. The bill that established the basic structures of the Data Practices Act was signed into law by Governor Wendell Anderson on April 11th, 1974. Fortunately for you all, I won't be singing happy birthday this morning, but I did want to make sure to note that the Data Practices Act has been around for half of a century now, and it's still going strong. So just wanted to note that it is its birthday today. Okay, the Data Practices Office is a small office in the Department of Administration, and we're a statewide resource on data practices and the open meeting law. Most of what we do is respond to questions related to those laws from members of the public and government. So if you have a question about these laws, please feel free to reach out to us at any time. We also assist the Commissioner of Administration with issuing advisory opinions and provide legislative assistance and training. This PowerPoint is posted on our website, so if you aren't able to download a copy today, it is on the page where you registered. We also record our webinars, so if you miss part of today's session or want to go back and watch it again or find one of our prior series, those are also posted on the Data Practices Office YouTube page. You can find more information at the URL listed on this slide, and we'll have another slide later with more information on accessing those resources after the webinar. If you'd like to download a copy of the PowerPoint right now, I am going to share a file for you to download and save to your computer. So one moment here. Okay, there should be a pop-up window that's appearing on your screen, and then you can select the file and download it to your device. If this doesn't work for you, and I know some people have had some issues downloading the files in the past, please just visit the webinar webpage on our website where you registered, and you can scroll down to the bottom to find this presentation to download. It should be under the Potpourri Data Practices Potpourri tab on the webinar page. All right, today's webinar is another installment of Data Practices Potpourri, where we highlight some of the questions data requesters and government entities have raised in the past month or so. We will leave some time for a Q&A session at the end of the webinar, so please feel free to send in your questions as you think of them using the Q&A panel on your screen. Make sure you choose all panelists when you send in your questions so we can be sure to see them. You can start sending those questions now, or you can wait until the end of the presentation. Okay, the first question we have is related to our office's role when it comes to providing technical assistance. We'll have government entities who reach out to our office with questions about not public data, such as whether specific data needs to be redacted. Other times, an entity will simply want to send us not public data along with a question. Often, the question that comes up is, can government entities share not public data with the Data Practices Office when seeking technical assistance or informal guidance? The quick answer here is no. Government entities should not be sending our office any not public data when asking questions related to technical assistance or to receive informal guidance on data practices issues. Although we certainly recognize that context often matters when it comes to data practices questions, there's no language within the Data Practices Act that provides statutory authorization to share not public data with our office when seeking technical assistance. In other words, a government entity would be violating the Data Practices Act if it shares not public data with us when asking questions. All that said, the Data Practices Office staff is well equipped to answer your questions without seeing the actual data that might be giving you some issues. You can generally describe the data and the questions you have, and we can definitely answer your questions from there. If we do have any confusion about the context of the data, we'll follow up with you to get some further clarity. But again, we'll never ask you to share not public data with us because we are not authorized to receive it. Our second question this morning we have is about managing the data request process. Specifically, the question is whether government entities are obligated to create and maintain a log of all data requests that they have received. This question is a really good one, and there's not a quick yes or no answer to it. Rather, it's important to note that the Data Practices Act does not have any specific requirements that a government entity needs to create a log that documents all the different data requests it has received. That said, there are several other considerations to keep in mind when thinking about this question. First, the Data Practices Act does require all government entities to establish procedures to ensure that data requests will be received and complied with in an appropriate and prompt manner. In other words, the Data Practices Act doesn't specifically dictate what type of procedures must be in place to respond to data requests. Rather, the law requires entities to have some type of procedures in place, and it's up to the entity to figure out which types of procedures work best for it. So, creating and maintaining a data request log may be one procedure that your entity can put in place to ensure that data requests are being tracked and responded to in an appropriate and prompt manner. Additionally, the Official Records Act does require government entities to create records that document their official activities, and the Records Retention Statute requires entities to maintain official records for the time period described on their records retention schedules. As a reminder, the law doesn't describe specific lists of official activities that each entity must carry out. Rather, entities do have some discretion over what they consider their official activities based on their various legal duties. But a helpful starting point to identify official activities is to review your entity's records retention schedule or review the general records retention schedules available on the Minnesota State Archives website. For example, the General Records Retention Schedule for Minnesota cities identifies data practices requests as official records that must be retained for 3 years, which means that handling data requests would likely be an official activity that must be documented for any municipalities following the General Records Retention Schedule. If processing data requests is identified as an official activity for your entity, then creating a data request log can help ensure that your entity has an official record of that activity. Additionally, your entity would be obligated to maintain the entries on the log for the period of time that is indicated on your records retention schedule. So again, the Data Practices Act does not specifically require the creation of a data request log, but creating and maintaining such a log may be a way to meet various statutory obligations. Our third question this morning involves personal devices. Specifically, a government entity received a data request for public data that could potentially be located on government officials' and employees' personal devices, including data in text messages on personal cell phones, as well as data in emails maintained in personal email accounts. The question is whether those data contained on personal devices or in personal accounts need to be provided in response to the data request. Yes, the entity would be obligated to provide access to the government data contained on personal devices and in personal accounts. As a reminder, the definition of government data is all data collected, all data collected, created, received, maintained, or disseminated by any government entity, regardless of its physical form, storage media, or conditions of use. In other words, the storage location doesn't matter when it comes to whether specific information is government data. Rather, it's the content and context of the information that dictates whether that information is government data. So, government data can certainly be maintained on employees' or officials' personal devices or in personal accounts, and these data may need to be provided in response to a data request. So our office knows that managing data requests for government data that are on personal devices can be complicated. So I just want to walk through a few tips and considerations that you can keep in mind when it comes to this issue. First, as a reminder, it's ultimately the government entity that has the obligation for responding to data requests. And the Data Practices Act requires that entities must maintain government data in ways that make the data easily accessible for convenient use. So if your entity does not know what data may be stored on personal devices or has no way to access such data, then you may be running afoul of these basic Data Practices Act requirements. Second, keep in mind that only the government data that are stored on personal devices are going to be responsive to data requests. If a public official is using a personal email account to conduct official business, then only the emails related to that official business will be subject to data requests. Other personal emails, such as messages to family members or emails confirming an online shopping order, will not be subject to data requests. In other words, all information in the personal account is not automatically accessible to data requesters. That said, do the very best you can to encourage your employees and officials to use government-owned accounts and devices. It's very likely that you or your IT services will have a much easier time accessing these government-owned accounts and devices, which means you won't necessarily need to rely on specific employees or officials to search their personal devices for data that are responsive to data requests. Alternatively, if you have officials who are really insistent on using a personal device, it may be worthwhile to set up a forwarding process that requires emails be sent to a government-owned account, and then that account automatically forwards the message to a personal device or account. In those situations, the government entity would still have access to the original messages. Lastly, it's worthwhile to consider drafting policies for your entity that describe how government data must be treated if it's stored on personal devices or in accounts. Some aspects of the policy may include the fact that official record retention requirements must be followed, as well as how data requests will be processed. Your entity can add provisions stating the various obligations that officials and employees must agree to in order to ensure applicable data practices requirements will be met. This can alert employees and officials that their obligations under the law about their obligations under the law, and may help folks reconsider whether storing government data on personal devices or in personal accounts is an appropriate approach to their work. Okay, for our fourth question, we're highlighting an easily overlooked provision within the Data Practices Act that doesn't come up too often. And the question that we have is, does the classification of not public data, not on individuals, change after a certain period of time? The quick answer is yes, the classifications do change after a period of time. Specifically, Section 13.03, Subdivision 8, states that not public data or protected non-public data become public 10 years after the government entity's creation, collection, or receipt of the not public data not on individuals. In other words, data not on individuals will be public if those data have been in your entity's hands for 10 or more years. However, there are a few exceptions to this classification. First, if the data are classified as non-public data because they are security information under Section 1337, then that non-public classification can still be applied to the data after 10 years. Additionally, the not public classification on the data not on individuals can still be applied when the responsible authority for the entity determines that if the data were to be disclosed, the harm to the public or to the data subject would outweigh the benefit to the public or to the data subject. Additionally, Section 13.03, Subdivision 8, describes a process in which the requester who is denied access to this data may bring an action in district court to seek the disclosure of this data. The court then must weigh the benefits and harms of disclosing the data before determining whether the entity must release the data. So this is also a pretty good reminder that your entity should have good data practices and records management processes in place to destroy any not public data not on individuals when it is no longer needed, or the retention period expires because it will become public at some point in the future. One last point here, we are only talking about data not on individuals when it comes to this specific provision in the Data Practices Act. Section 13.03, Subdivision 8 does not apply when the underlying data are related to living human beings. Generally, the classification of data on individuals doesn't change after a certain period of time unless specifically noted in the law. Okay, here's a question about data requests that's come up a few times and in a few different instances over the past couple of months. In this situation, we have a data requester who completes a government entity's data request form and checks the box indicating that she would like to both inspect the data and obtain copies. The entity is wondering whether it can require the individual to prepay for copies before beginning a search for the responsive data. The short answer here is no. The government entity cannot require the data requester to prepay for copies immediately. Let's walk through this analysis. So essentially what you have in this situation is a two-step data request. The first step is that the requester is asking to inspect data. The second step is that the requester is signaling that they will be asking for copies of data after inspection is completed. As a reminder, government entities cannot assess any copy costs or other fees when an individual wants to inspect data. Under Section 13.03, Subdivision 3, inspection is always free, regardless of the amount of data that is responsive to the request. As a result, a government entity cannot require a requester to prepay for copies of data when the first part of the request is for inspection. However, your entity should document its work related to any applicable copy cost fees that can be assessed when requesters indicate that they are also interested in obtaining copies. It's very likely that you'll be able to charge copy costs at some point, and it may be difficult to recreate what those costs may be if you're not documenting them while searching for data. Of course, once inspection is completed, you can then require any prepayment of costs prior to providing copies. It's reasonable that copies may not be immediately available after inspection because, again, this is a two-step data request. In other words, your entity has a reasonable amount of time after inspection to provide the public data requester with copies, and you can require prepayment after inspection but before providing copies. As a final note, you may want to review Advisory Opinion 04-038, which was a situation where the requester inspected a large amount of data but asked for copies of a smaller portion of the overall data. The commissioner opined that entities cannot charge copy cost fees for all data produced for inspection. Rather, entities must prorate the copy cost fees to reflect the amount of data that are reproduced as copies. So, if a requester inspects 1,000 pages of data, but then asks for copies of only 200 pages, then the entity can only charge the requester 20% of the total actual costs related to search and retrieval of the data, as well as for the preparation of copies and the costs of materials. Okay, let's take a quick detour into law enforcement data because this is a question that I've seen in recent months a few times from both requesters and law enforcement agencies. The question is whether a law enforcement agency can disclose a state accident report when the report is related to an active criminal investigation. For some context, state accident reports are specific reports that law enforcement agencies must complete after an accident that involves injury or death or certain amounts of property damage. Typically, these reports are available to parties involved in the accident. However, any active criminal investigative data that law enforcement agencies maintain are going to be classified as confidential or protected non-public under Section 1382, Subdivision 7. Essentially, this question comes down to whether state accident reports can be classified as confidential or protected non-public data when the report documents an accident that may have involved some type of criminal activity, such as criminal vehicular operation. So the law isn't directly clear on this issue, but the answer is yes. State accident reports should be disclosed even when they are related to an active criminal investigation, and I'll explain the analysis. The language in section 169.09, subdivision 13A, states that upon written request, any law enforcement agency must disclose the state accident report to individuals who are involved in an accident or to the deceased's estate or surviving spouse and kin when an accident results in a death, to other persons who are injured in person, property, or means of support or incurs other financial loss as a result of the accident, as well as to the legal counsels or insurers of any of these parties. Importantly, there's no language in Subdivision 13 that states law enforcement agencies can withhold a state accident report because it's related to an active criminal investigation. In short, the law states that law enforcement agencies must disclose the state accident report upon request from authorized individuals and makes no exceptions to withhold the report from someone who is authorized to receive it. From a practical standpoint, most data in the state accident report likely fall within the categories of always public data under Section 1382, subdivisions 3 and 6, which means the data would already be disclosable while an active investigation is ongoing. Additionally, individuals can obtain state accident reports directly from the Department of Public Safety at any time. So it's unlikely that the legislature intended that there would be different levels of access to these reports between different government entities. So law enforcement agencies are obligated to disclose state accident reports upon requests from authorized individuals, regardless of whether the report is related to an active criminal investigation. However, any additional data that the agency collected as part of the investigation that is not documented in the accident report would remain classified as confidential or protected non-public under Section 1382, Subdivision 7, while that investigation is active. Okay, the last question we have today. The legislature is still in session and considering a lot of different bills that would make changes to the Data Practices Act, as well as the open meeting law. Is there a good way to learn about all the changes that are made to these laws? Yes, our office puts together a legislative recap in our July FYI newsletter that provides descriptions of the changes that are made to data practices laws, including the Data Practices Act and provisions in other statutory chapters, as well as the changes made to the open meeting law. You can receive this newsletter by signing up for the Data Practices Office's email list. If you're attending this training, there's a pretty good chance that you're already signed up to receive our email newsletter. If you're not signed up, you can go to the Data Practices Office website and scroll to the bottom of the page. At the bottom, you'll see a small box where you can enter your email address to receive emails from us going forward that include our newsletter as well as announcements for our upcoming trainings. So those are our questions for today. Let's take a look at some of yours. Remember to send them to all panelists so we can be sure to see them. Uh, and a few reminders on the slide as we're starting to take a look at the questions. The slide deck is available on our website, and you can also access the recording on our YouTube page in the next day or two. I'm also going to be putting an evaluation in the polling panel here in just a few minutes. So if you would please fill that out and let us know how we did this morning and what other topics you'd like to see in the future, we would definitely appreciate it. We want to make sure that these webinars are helpful and useful to you. So thank you in advance for your feedback.
All right, we've already had a few good questions come in here. So let's start with our first one. Regarding number 3, the question says, so this is the slide that we had regarding government data on personal devices. And the question states, how broad is government entity in the definition of government data? Does this mean that someone could request and receive my text messages with my boss about working remotely or staying home due to illness? So I just want to clarify with this question, just because something's government data doesn't necessarily also make it public. So you first start out with, is this threshold question of whether something is government data. And if it is, then it's responsive to a data request. And so for something to be government data, it has to be created or maintained by a government entity. And so you as an employee can create government data as part of your job and have that data maybe on a personal device like your phone or computer. But then it's your responsibility and the government entity's responsibility to make sure that those data are maintained properly and provided in response to a data request if they are public. But that's the second part of this question, right? So this question gets at text messages about maybe staying home due to illness or other personal issues maybe that you're dealing with as an employee. And some of those data might be private personnel data. And so just because government data doesn't necessarily make it public, we start out with that public presumption, but you have to look at the actual content of the data to then make a classification determination. And so if you get a data request for your text messages that contain government data, you first have to find what's responsive. You can go to your supervisor or the person who's coordinating that data request response, and then from there go through and determine whether any of those are actually public in response to that request. I hope this helps answer that question. If not, feel free to reach back out to us or send another follow-up in the Q&A. We have another question here that asks, when withholding data based on Minnesota Statute 13.393, does any provision of the Data Practices Act require a privilege log as required by the rules of civil procedure? No. So the short answer is no. Those are two separate types of requests, right? So a discovery response and a data request trigger two different rights. With data practices requests, you are obligated to cite the statutory authority, cite the specific statutory section or temporary classification or specific provision of law that classifies the data as not public, or in this case, it makes it not government data, right, under 13393. So you would just cite Minnesota statute 13393 as making the data not accessible to the data requester in this specific instance.
Thanks, Katie. All right, we have another question here. So does the Data Practices Act contain a provision authorizing requester to demand a hold on the deletion of data pursuant to the entity's document retention or deletion processes? So the Data Practices Act doesn't have a provision that would allow a member of the public essentially to request that an entity not follow their retention or deletion processes. But if the requester does have a pending data request, so say they've submitted a data request to your entity, then your entity is obligated to provide the responsive data that it has to that request at the time it receives the request. So let's say you had a bunch of emails that you could have deleted under your retention schedule, but you didn't. You receive a request. You can no longer delete those emails at that time. They have to be provided in response to the request. But there's not a process through the Data Practices Act for a member of the public to essentially proactively ask an entity to retain its data. So if you do receive, like a litigation hold or something, that would be an analysis outside the Data Practices Act to consider whether or not you need to retain those documents. But under the Data Practices Act, there's not a provision itself where they would make that request. All right, we had another question here. So can an agency require a consent form notarized for individuals requesting body-worn camera to consent to have their data and image be public or not redacted? So there is a provision, right, where if the subject of the data requests that their body-worn camera be made accessible to the public, they can do that. They can also provide consent for other individuals to request copies of that data and not have their identity be redacted. And you as the entity have to be confident, right, that you're receiving those requests from the subject. So I do think that you have some flexibility here in terms of what form you require from the data subject when they're making these requests so that you can be confident that the consent is valid, that it's coming from the actual subject of the data. So you are permitted to use, forms for data subjects to clarify their requests so that you feel confident in the consent that you're receiving.
Okay, I am just going to open the poll here quickly. So if you would take a few minutes to fill that out, but we do have a couple minutes yet and we'll continue to answer some questions, but I'm going to open that poll for everybody to start completing. Okay, and so the next question that we have here is, can you please clarify in the public request for state accident reports contained in a case report from a non-authorized party under 169.09, would state accident reports be classified as investigative data, available in inactive cases, but withheld in open active cases? That's a good question. So what 169.09 subdivision 13 says is that the reports are confidential. This is in the header of that subdivision. And so I think that's being used more in the colloquial term, not necessarily as in the reports are confidential, classified as confidential data. But generally, these state accident reports should not be available to members of the public. Really what that section in subdivision 13 says is that these reports are really only available to the specific folks described in subdivision 13 that we talked about on the previous slide. And so really keep that in mind. You shouldn't be disclosing that even if it is an inactive investigation. And in fact, subdivision 13 does have some language in there that, disclosing any information in the state acts or disclosing information in the state accident report, except for as related to 1382 subdivisions 3 or 6, is a misdemeanor. So you should not be disclosing those state accident reports to anybody else, even while an investigation is inactive. And one other question we have here is a government entity required to respond with statutes stating why particular government data is not released or redacted if it is asked for in the request. Yes, government entities are obligated to provide a statutory justification for why they are withholding data from a public data requester, or even from someone who is maybe asking for private data about themselves under 13.04. And so there is that requirement to provide that statutory justification. And you can find the specific language. It's in section 13.03, subdivision 3F is where it states that government entities must provide that statutory reason to justify withholding access to data. And so that's the language right there.
Okay, we have another question here. It's a follow-up to charging for copies after you've received an inspection request. It asks about, the government entity charging for employee time after they've already accumulated the data for inspection, and how they would go about doing that. In the slide regarding this question, we cite advisory opinion 04-038. And the first issue that's discussed in that advisory opinion walks through this kind of proration analysis, where if it's part of one request and the requester comes in and asks for inspection and then wants to leave with copies or request copies of a subset of the data that have been inspected, you can charge a prorated amount of the copy costs based on the data that are collected as part of that inspection. So I would suggest looking at that issue 1 of that opinion that talks about the analysis of charging a prorated amount as part of that same request.
Okay, so thank you everyone for the questions. That is our time for today, but we appreciate your attention and sending those questions. A lot of great ones. If we didn't get to your question, we will write it down and follow up with you to discuss it. And so we will be reaching out to you. But again, stay tuned for Gov Delivery notices for our upcoming workshops and webinars. We do send those out regularly. You can sign up for that on our website. And we will be sending out information, and we have another FYI coming out next month. And so that information will be coming soon. So again, thank you for joining us this morning, and have a good day.